As we added Rhode to the pile of victories for Second Amendment litigation here in the state of California, when we saw last week an opinion from the Ninth Circuit drop claiming that Prop 63's ammo regulations are unconstitutional, after about a week, it's time to take a little bit of a deeper dive and examine the ramifications of what happened last week. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, the victories keep rolling in, and with the recent victory that we saw last week in Rhode v. Bonta, I thought it would be a good idea to go ahead and rehash it now that we've had a little bit more time to analyze the opinion, get the lawyers' eyes on it. So to walk us through that today, I have brought back on CRPA's president, that is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. So I guess, Chuck, we can start where I kind of left off in the last video in talking to Sean. There was a lot of language in that opinion, really narrowing down on the idea of an ammo purchasing scheme. Now, in the challenge, which we went over in the last video, all the different challenges that we had to Prop 63, it's more than merely just a background check. So, after looking at the opinion for a little while, I guess, can you go ahead and explain what they mean when they say background check scheme when it comes to purchasing ammo through FFLs?
Yeah, remember this all started because of Prop 63, which was Gavin Newsom's ploy to increase his name recognition when he was running for governor. And it did a bunch of things, one of which was the ammo background check, but it was fairly simple. I mean, don't get me wrong, it was a constitutional violation even then, but it was fairly simple. In Prop 63, you had to show, you could basically have a card that showed you were eligible to possess and own firearms, and so you would therefore also be able to purchase ammunition. It was a relatively, comparatively simple process. After Prop 63 passed, the legislature had to get in there and tinker with things, as they do so poorly, and they made it a much more complicated system where they needed to know that you were restricted on the types of calibers ammo you could buy unless you had a gun registered in that caliber, and you had to fill out a bunch of paperwork, pay a fee. In other words, it became very problematic, and DOJ's background, their criminal conviction database is in shambles. That's what the public auditor concluded. So you're getting like 12% rejections because the people aren't actually prohibited, but the database shows they are. And then the people don't take the time to straighten it out, because if you're a new shooter and you're trying to get into the shooting sports, or you want to go to the range but you can't get the ammunition, a lot of people give up. And that's what happens. And that's what they wanted to happen, because this is not really about ammo background checks to make sure a prohibited person doesn't buy ammunition. It's about making it as difficult and expensive and cumbersome as possible to buy a gun or an ammunition, or to go to a gun show, or to go to a gun store. It's all part of the war on the gun culture that Gavin Newsom has admitted he's involved with. So because it became so complicated, it was much more vulnerable to a Second Amendment constitutional attack.
But that scheme in general, and the reason why I wanted to focus on this is because you could, I guess in theory, read through this opinion and say, oh, okay, of all the things that we have to do in order to purchase ammunition, all the restrictions that we have, whether it's trying to get ammo across state lines, having to go through an FFL, all of these things in the regulations in Prop 63 really are included on this. It's not just a statement by the Ninth Circuit saying the background checks specifically are unconstitutional. It's the background scheme as a whole. So it's important to understand that there are many moving parts in a grand scheme, and the Ninth Circuit here, I guess kind of in an unprecedented way, since they didn't rule on Rhode the first time they had it, said that the scheme itself was unconstitutional. But what about the procedure after that? Chuck, we've talked a lot. We've talked through a lot of cases. In some cases, you have an opinion come out where an injunction is put into place, where literally it's like the opinion happens one day, you're not allowed to purchase magazines with 10 rounds, and then the next day you can. Can you walk us through the procedural portion of this, where it sits in the Ninth Circuit right now with Rhode?
Sure. So we got a ruling from the three judge. Okay, first of all, remember, we tried the case in San Diego in front of Judge Benitez. We got a judgment from him that said that this background check scheme, all of it together, is unconstitutional. It's a Second Amendment violation. It's an undue burden on the exercise of your Second Amendment rights. That judgment was appealed to the Ninth Circuit to a three-judge panel. Now, when the trial court, Judge Benitez, ruled, he issued an injunction saying law enforcement is prohibited from enforcing this law. The law is blocked. You can't require any of this stuff. The state then ran to the Ninth Circuit and said, we need a stay of that injunction so the law remains in effect. The Ninth Circuit gave them that. We opposed it, but the Ninth Circuit gave it to them. Now, that stay of the injunction is still in place. It was not addressed. It was not addressed by the three-judge panel. They said it's unconstitutional, but they did not lift the stay of the injunction, so the law is still in effect. Now, we will probably be fighting fairly soon to lift that stay as the case moves forward. But what's going to happen next is the state has the opportunity to seek en banc review, and this is the game they play almost always. They didn't do it in the Junior Sports Magazine when we got that unanimous court ruling striking down the ban on marketing to junior shooters. So that is back down in the trial court again. But that's what happens. If they don't ask for en banc review, then the three-judge panel issues a mandate, it's called, and that gets sent back to the trial court to wrap up the case. So in this case, they have not issued a mandate. They have not lifted the stay. The state will now seek en banc review, I have no doubt, because that's the game they play. And then we can try and we will oppose en banc review. There's no need for it. This panel got it right. And we will oppose keeping the stay of the injunction in place, but more likely the Ninth Circuit, because their general approach is to maintain the status quo. And the status quo right now, after however many years the background checks have been there, is to have this law in place. We'll fight that, but then there'll be a decision by the en banc panel or the Ninth Circuit whether to take this case for an en banc hearing in front of 11 judges instead of 3. And if there is, then we'll oppose it. But if there is, then we'll have briefs in the en banc panel and another oral argument in front of the en banc panel. Then we'll either win or we'll lose. If we lose, we will ask the Supreme Court to take the case, as we have with Duncan, the magazine possession ban. And there's a good chance that they will, because this is a case that has a judgment in place. It's not a preliminary injunction case. They don't like those cases that are not fully cooked, not fully developed. This case, Rhode, we had expert testimony. We had all kinds of documentary evidence. I mean, we had a full-blown trial and a final judgment based on that trial. So it's much more well-postured for the Supreme Court to look at it. Plus, I mean, this is really a very restrictive. This is a way to chill the Second Amendment, to stop people from going through the trouble to exercise their Second Amendment rights. And that's, again, what the state has in mind. That's what Gavin Newsom has in mind. That's what they're trying to do, make it as hard and as expensive as possible to get, own, and use a gun.
So you have an opinion, which I guess these words end up coming into play finally. You say words a lot, you don't necessarily think about them, but so essentially what you're saying is we have an opinion from the court, but we don't have a mandate from the court. So the court told us their opinion. That opinion is that this law is unconstitutional. They have not yet delivered a mandate that would state to law enforcement that they should not be enforcing this law. So that makes
Michel, we have a ruling, but it's not a final ruling yet.
So I guess where's the silver lining here? What benefit does this opinion, which again is unprecedented from the Ninth Circuit? We didn't get an opinion from them the first time this lawsuit came around. What benefit to the 2A community do we get from the Ninth Circuit 3-judge panel claiming this background scheme is unconstitutional?
Because there is growing understanding and growing acknowledgement and growing compliance within the Ninth Circuit to properly apply the Bruen standard, the Bruen methodology. They could have said ammunition isn't an arm. They could have said the Second Amendment doesn't even apply because ammunition is not an arm. Only the firearm is an arm. Well, a firearm is not worth much if you can't get ammo for it. So for starters, they interpreted the scope of the language of the Second Amendment correctly. It's expansive. It's not just the firearm. It's the magazine. It's the sights. It's the ability to take it to the range to practice. It's the ability to use it to defend your family. All of that is part of the right to keep and bear arms. So for starters, the courts acknowledged, unlike Duncan, where they said magazines that hold over 10 rounds are not arms. They're not even protected by the language of the Second Amendment in the first place. So at least they said ammunition is covered by the language of the Second Amendment. Then they jumped to the second step and said, is there any historical analog law, a similar law from 1791 or thereabouts, that would justify, which would reflect that the founding fathers would have tolerated this modern day law? And again, this panel got it right. They looked at the laws that the state tried to hold out there and say, well, look, they required surety when you wanted to take a gun out in public, and they use some very far-fetched historical examples when they try and justify a modern day law. And that's what they did here. And they got called on it because it didn't meet the Bruen test. You have to ask why the founding father era law existed and how it was put into effect. And if those things match, then the modern law may be sufficiently similar to the historical law to justify the modern day law's existence as not unconstitutional. But the court looked at what the state put out there and said, no, that's not the same thing. So that's a faithful application of Bruen. But some courts will bend over backwards to say that a Bowie knife law justifies a semi-auto ban. I mean, that's how far some courts are willing to stretch. So that is a good sign. And it's a sign that more and more courts, judges on the Ninth Circuit, are recognizing what their obligations really are under Bruen and not trying to get around them.
So, I mean, it sort of sounds like what you're saying is if we can get the stay lifted, or if we can get that mandate, that will be a victory in this battle. But this opinion overall is a victory in the war. It's really showing that the Bruen effect is setting right a lot of the unconstitutional things that we have here in the state. And again, guys, the Ninth Circuit has not been the friendliest to the Second Amendment in the last decade, and even a little bit beyond that. So to see a 3-judge panel at the Ninth Circuit rule this way is a good thing. I think it's great, and we're going to put that test to the Ninth Circuit. My assumption is really in line with yours, Chuck. I can't really imagine in today's age the state not appealing to the Ninth Circuit, and we're definitely going to follow along for all that stuff, but still a big victory in the war here as they have to recognize these rights at the Ninth Circuit. So along with other victories that we've had, right? We just saw a victory in the Junior Sports Magazine case. The Duncan case is going to get filed with the Supreme Court soon. There's a lot of hope and promise behind that one, along with a couple other cases that we've seen victories in recently. So Chuck, I guess overall, and that's right, the CCW lawsuit against LA County Sheriff. So, in seeing all of this, what's the pattern that you're seeing in the courts? And then for Rhode specifically, what's the path forward and the potential timelines that you see here?
Okay, so the larger war, and we are winning multiple battles and fighting multiple other battles in that larger war for the proper application of the Bruen methodology. ultimately, that war is going to be set, that battle, that ultimate battle, and the resolution of the, well, it'll never be resolved, but because developing a big area of the law like this, I mean, First Amendment took a decade to really flesh out the parameters of free speech. But we are fighting multiple battles in a dozen different cases, winning those battles. Ultimately, the next big battle that's going to be decisive in the war is what the Supreme Court says in Duncan or whatever other case they accept in the next session. But as far as Rhode is concerned, we're going to see the state will note I think they have 14 days to ask for en banc review. The state will no doubt seek an extension, and they'll get one. And then we'll oppose their request for en banc review. We'll oppose their attempt to keep the stay of the injunction in place, and then we will have to submit legal briefs and then before the en banc panel, probably have an oral argument in front of the en banc panel, which will take months. And then if we lose, we'll ask the Supreme Court to take the case, and that would be another. If the Supreme Court takes it, candidly, it would be another year to get a decision out of the Supreme Court.
Well, certainly sounds like there are some dates coming up. We're going to want to follow along with each and every one of them. So, Chuck, I want to thank you for coming on and doing a little bit of explaining today. I know you're a busy guy. I appreciate the time, and I appreciate the wisdom.
People just need to keep in mind, this is not, we are making history here. We are making Second Amendment history, not just for us, but for our children and our children's children. I know it takes a long time. Believe me, I don't like it taking this long. But that's the game that the state is playing, and that's the system that we're stuck in. So you just have to hold on to hope. We are going to win. We are going to win the war, not just these battles, the war. And so, if you can support our efforts, you will be a part of the history that we are making, and you will help make it possible for us to win that ultimate battle and win the war.
Yeah, I couldn't agree more. And guys, the best way that you can support, they're in the description below. Become a member. Just go ahead and click the link. Become a member today, whether you're in California and you are being suppressed by these laws, or if you are out of state and you just want to make sure that these laws don't find their way over to you. Go ahead, hit the description, and become a member today. You can also like, share, and subscribe. Really helps. Also, it's a direct way to contribute to the legislative and litigative efforts, just like Rhode, that you're seeing unfold right now. And we're going to continue seeing it unfold. Chuck, thank you very much again. I appreciate your time.
Thank you, guys.
Absolutely. Guys, one more time, hit the like, share, and subscribe buttons. It really helps. It goes a long way. We want to get this message out as far and wide as possible. Thanks again, guys. We'll see you on the next one.